I'll be talking to you about trade secrets and the future of non-competes, what the proposed federal non-compete ban means for trade secret protection, and how businesses should prepare. I'm Max Goss. I'm an IP and business litigator. I do a lot of trade secret work. To start, I have a confession to make. I have 68 slides and 20 minutes. So I will not be dwelling on each and every slide. However, for anyone who's interested, I would encourage you to contact me after the presentation. I'll be happy to give you the full set of slides. My goal in putting them together was to create a comprehensive guide to where we are today and where we're going next with respect to non-competes. I'll be breezing through some of it right now, but hopefully it's a resource. The full slide set is a resource for anyone who might like to use it. So for those of you who are not aware, the FTC, the Federal Trade Commission, has taken steps to impose a sweeping ban on non-compete agreements. Just earlier this year, on January 5th, the FTC announced a proposed rule that would impose a ban on employee non-compete agreements. That's Lena Khan, the pro-labor firebrand that President Biden appointed as the chair of the FTC. The ban that is being proposed would be nationwide. Right now, as many of you may know, there's a tremendous amount of variation among the states with respect to non-compete law. This would be a nationwide ban. It would be categorical in the sense that there are virtually no exceptions to the ban. There are a couple negligible exceptions which we'll discuss, but they truly are negligible. And it would be retroactive. That is, not only would businesses be barred from using non-competes going forward, they would also be required to retract their existing non-competes that they have today with employees. So pretty drastic steps being contemplated. So are non-competes doomed? Is this it for non-competes? I love this slide. I showed it to my wife and she just said, I thought it was so funny, she just said, why is it a chicken? I guess it just depends on how it strikes you. I liked it. So is it doomsday? Well, the exact outcome is uncertain. As we'll discuss, this could go a lot of different ways. This proposed ban, it may get passed as written. Another variation might be enacted. There's certainly going to be a lot of fighting over it. But one thing that is certain is disruption is coming. Absolutely, change and disruption are on the horizon in the world of non-competes. And so employers, any employer, any business that uses non-compete agreements with employees needs to take steps now, and not wait around for the ban to be enacted, but today is the day, or now is the time for employers to put a plan into action and start taking steps to prepare for whatever it is that may come. Just a quick roadmap. I'm going to start with a couple sections, just giving some context, then I'll do a deeper dive into the details of the FTC's proposed ban, and then I'll give some concrete suggestions for what businesses can do now. So first, let's talk about trade secrets and non-competes. According to my timepiece, I'm right on track. So what is a non-compete? Just to level set, a non-compete agreement in the employment context, which is the most common context for non-compete agreements, it's a contract between an employer and employee that restricts where the employee may be employed or provides services after the employment ends. For example, an employee might be restricted from working for a direct competitor within the Tri-County area for a period of 12 months, for example. What are non-competes for? Frankly, I think this is a question that sometimes gets overlooked by attorneys and by the businesses they represent. But what are non-competes for? Well, first and foremost, the purpose of a non-compete agreement is to protect trade secrets and confidential information. some jurisdictions recognize other legitimate business interests that may be protected by a non-compete. But first and foremost, trade secrets and confidential information are what non-competes are designed to protect. I won't dwell on the definition of trade secrets, but I will note that trade secrets are absolutely pervasive. The overwhelming majority of CEOs say that proprietary information is essential to my organization's value. There are many, many kinds of trade secrets. Virtually any kind of information, whether it's technical information, things like engineering specs or software, or business information, something as mundane as the lowly customer list, provided that it is robust enough, can be protected as a trade secret, and other things like financial information, market research, and so on. So really, any kind of information, pretty much, can be protected as a non-compete. They're absolutely everywhere. In my view, every business, or virtually every business, has non-competes or confidential information in some way, shape, or form. And I think very arguably, trade secrets are one of the main drivers of the modern economy. Well, what do non-competes have to do with trade secret misappropriation? Here's how a non-compete works. A non-compete agreement temporarily bars the employee from taking a position where he or she could easily disclose or use the employer's trade secrets, whether inadvertently or intentionally. So this is a significant point. Trade secret laws, for example, the Michigan Uniform Trade Secret Act, or at the federal level, the Defense Trade Secret Acts, they have some very powerful tools. They are very powerful tools for protecting trade secrets, but they generally only act after the fact, after the misappropriation has happened, after the horse is out of the barn and the damage is done. The unique value in non-compete agreements lies in their ability to prevent trade secret misappropriation from happening in the first place. There are a lot of risk multipliers. In my view, trade secrets not only are more important than ever before, but they're also more at risk than ever before. We're seeing a lot of changes in the workplace, a lot of them due to what we saw in the past 2 years during the COVID-19 crisis. You may have heard of the Great Resignation. There's been a huge spike in employee mobility. And also, as we all know, remote work is very much part of our lives now. And I don't think we're going back. And that creates new vulnerabilities for trade secrets. Here's some stats backing up what I just said. Couple that with changes to technology, information and business is getting more digitized than ever, more than ever before. Every single bit of information that we create or use or touch is in digital form. And more of it is stored in and accessed on the cloud. Another risk multiplier, another thing that makes our trade secrets vulnerable is that they're out there in the cloud and often accessible on personal devices, which we see being used more and more. Many employees have a personal mobile phone or a laptop or another device that they use to access an employer's trade secrets. So the opportunities for trade secret theft or even unintentional loss of trade secrets are greater than ever. Here's some more stats. Bottom line, if any of you know me, you know this is one of my mantras. Trade secrets are easy to steal. Trade secrets are easy to steal. All it takes is for an employee, for an example, to stick a flash drive in a computer, upload some documents, stick it in his or her pocket, and walk out the door. And in a matter of minutes, a company's crown jewels can be lost forever. So just as a quick roundup of what we covered, the whole point of a non-compete is to protect trade secrets. Trade secrets are hugely important, and the loss of them is irreparable. Trade secret theft has gotten really easy, easier than ever. And the distinctive or unique value of a non-compete is that it can prevent trade secret theft from ever happening in the first place. Well, if non-competes are such a wonderful, valuable tool, what's the problem? What's the uproar? Why does the FTC want to ban them? So let's talk a little bit about what are seen as the problems with non-competes. If you want to understand non-compete law, you have to understand one proposition, or you got to start with one proposition, which is that non-competes are disfavored because they are restraints of trade. You may remember that phrase, restraint of trade, from law school. A restraint of trade is an action that inhibits free market competition, and a non-compete, it's a restraint of trade. It just is. It inhibits competition in the labor market. So because of that, non-competes are subject to intense scrutiny, much closer scrutiny than other types of contracts. In most U.S. jurisdictions, a non-compete's only going to pass muster if it's reasonable in its scope and reasonable in its purpose. Other contracts, courts don't give it that kind of scrutiny. Non-competes, they do give it close scrutiny. Standards vary throughout the United States. Every jurisdiction has its own set of rules and standards for evaluating non-competes. There are a couple jurisdictions where they are barred or virtually barred, but in almost all U.S. jurisdictions, they are allowed to a greater or lesser extent, and laws vary. They vary regarding the reasonableness of the scope of a non-compete, geographic and temporal, and with respect to an industry or line of employment. They vary with respect to the business interests that may be protected by a non-compete. They vary with respect to the consideration that can be exchanged for an employee's undertaking of a non-compete. Reformation, different states have different rules about blue pencil, red pencil, equitable reformation. Exclusions. In some jurisdictions, physicians or certain types of physicians cannot be subject to non-competes. That's an example. A growing trend is that non-competes for low-wage workers, workers who earn below a certain threshold, are barred in a growing number of jurisdictions. Really, that's just a start. There are many, many ways that non-competes vary among the states. Well, there have been a lot of criticism over the years, and it's really developed into a drumbeat in maybe the past decade or so. The FTC pointed out in the 200-page paper that it promulgated in conjunction with its proposed rule that non-competes can impact employee mobility. They can make it harder for employees to move around from one job to another and make it less likely that they will take advantage of opportunities and move from one job to another. And kind of going hand in hand with that is non-competes can suppress wages. The FTC cites studies saying that jurisdictions that allow non-competes see lowered wages because of it. Of course, there's two sides to every story. There's also studies that can be cited in favor of the use of non-competes. For example, there was a really interesting study in Michigan where non-compete law really flipped in 1985. And there was a long-range study for about a 25-plus year period after 1983 that showed that non-competes can encourage job creation among startups. Studies also show that firms are more likely to invest in employee training if they have some assurance that the employee is not going to move over to a competitor. Now, in citing these studies, I'm not here to evaluate them either way. That's not the purpose of my talk. It's rather just to give you a taste of some of the evidence for and against. One very important point is trade secrets. Again, the whole point of a non-compete is to protect legitimate business interests, usually trade secrets. Well, trade secrets, according to one government study, the loss of trade secrets theft, accounted for 1% to 3% of the gross domestic product. Another study looking at federal trade secret litigation, and this won't surprise anybody who does trade secret litigation, found that in 85% of cases, the alleged trade secret thief was an employee, was a business partner, was somebody on the inside. While these things have been true for a long time, and people have been studying non-competes for a long time, why is the FTC acting now? And I would suggest that one reason that things have come to a head lately is we see more and more widespread abuse of non-competes, and those abuses are getting more and more attention. They get abused principally by getting unhitched from their proper purpose. Many attorneys will, almost as a matter of course, just include a non-compete agreement in an employment agreement without serious consideration to whether the employee has substantial access to non-competes and whether the non-compete agreement is actually necessary to prevent the misappropriation of those trade secrets. Famous example, around 2014, 2015, attorneys general from 2 states cracked down on Jimmy John's, which was using non-competes for employees at all levels, including even those people who were making sandwiches. It's hard to know what kind of trade secrets were being protected. Do you put the turkey down first or the ham down first? Unlikely they were exposed to substantial trade secrets. Jimmy John's eventually settled with both attorneys general. Again, if you ask for the slides, you can take a closer look at this. But just a pointer for any attorney who deals with non-competes. Make sure that it's hitched to a legitimate business purpose. Well, there have been a lot of reform efforts because there's an increasing problem and an increasing perception that there's a problem. More and more states are passing non-compete statutes. Just in the last few years, more than half of the states have passed new non-compete statutes. There's also the Uniform Law Commission has come out with a model Uniform Restrictive Employment Agreement Act, which has already been enacted in one state. And of course, Congress is taking a look at it too. There have been a number of bills that have been presented in the last year or two. So just a quick roundup. Non-competes are a restraint of trade. That's why they have to be reasonable. That's why they get scrutiny, and the abuses draw scrutiny. But many state and federal legislatures are developing solutions that in most cases stop short of a total ban. Well, let's talk about the push by the FTC to ban non-competes. President Biden issued an executive order calling for a crackdown on non-competes. I think a lot of people looked at this and said, surely they won't go all the way and really try to ban non-competes. Well, that's exactly what they did. As I mentioned earlier this year, the FTC proposed a rule under which it would be unfair competition for an employer to enter into or attempt to enter into a non-compete clause with a worker, or to maintain a non-compete, or to tell a worker that the worker is subject to a non-compete. This ban is very sweeping. It would prevent an employer or prohibit an employer from entering a non-compete with a worker, from maintaining a non-compete with a worker. So if you have an existing non-compete, you can't maintain it or enforce it. And you wouldn't be able to represent to a worker that the worker is subject to a non-compete clause without a good faith basis. The ban extends to all workers. That covers both employees and independent contractors. So don't try to get out of it by 1099ing your employee. There's a couple narrow carve-outs which I won't dwell on except to note they're truly narrow. Franchisees and sales of business in certain circumstances. What's really important here is that the FTC will apply a functional test. Just because it doesn't say non-compete at the top doesn't mean it's not a non-compete. They'll look at the nature of the agreement to see whether it prohibits an employee from seeking work. There are certain NDAs. I'd be happy to chat with you about this afterwards. There are some NDAs that can constitute non-competes, and there's actually some interesting cases out of California where this question's been considered. Certain reimbursement agreements where an employee agrees to reimburse an employer for training if the employee leaves within a certain time. Those can be a functional non-compete. Employers are required to rescind their non-competes, or will be, as soon as this is promulgated, or if it is, and to provide notice to all of their employees that it has been rescinded, that their non-competes have been rescinded. Preempt state law. In the compliance state, we don't have a compliance state yet, but it would be 180 days after the rule is published. Right now it's a comment period. There are some organizations pushing for an extension of the comment period, but on the track that it's on right now, potentially there could be a nationwide non-compete ban as early as this September. Here you have a jackbooted thug waiting to take away your non-competes. Well, people are asking questions. These questions alone, probably each of them could be a whole presentation in itself, but there are questions about whether the FTC has authority to do this. Can it do it without congressional authorization? Can it go and cancel provisions in millions of existing contracts and so on? There are questions about the prospects of the ban. Will the FTC really try to do it, the full ban? Or will it try something more modest? What will happen to pending injunctions? Perhaps most importantly, if and when a full or partial ban is challenged in court, when will this rule actually take effect? Lots of questions about what would constitute a de facto non-compete agreement. A lot of landmines there, potential landmines. And lots of other questions too. What about garden leave agreements? What about when an employee maybe didn't have a non-compete, but leaves the employer and signs a 7 agreement, gives the employer a release, accepts some money, and agrees to a non-compete? Are those covered by the ban? We don't know. Similar question when an employee settles a lawsuit with an employer, and so on. Again, the FTC proposes to ban all non-competes. Employers will have to rescind them and notify their employees that they've done so. The FTC will apply a functional test, and there are many, many questions surrounding what the FTC is proposing. Well, what should businesses do now? As I said, I think waiting to see what the FTC does is probably not a prudent course of action for businesses that are using non-competes. Here are several strategies. Number 1, get informed and stay informed. Pay attention to what courts are doing. Stay apprised of statutory changes. Any attorney you counsel business clients, any client that has employees, should be doing this, and all of you are doing it by attending this presentation. Strategy 2, review and update your non-competes. Now, proactively, prospectively. Here's an interesting fact. The FTC is already cracking down on non-competes. It doesn't have the ban, but it has found cases where it thinks that non-competes are being used in an unfair and oppressive manner, and it has already been cracking down on businesses. This would be a great time for employers to make sure that their non-competes are narrowly tailored to serve a legitimate business interest, and to make sure they're reasonable. Strategy 3, review and update your NDAs. There's some landmines here. The FTC is very explicit that some NDAs, believe it or not, could constitute non-competes. Many NDAs are very, very broadly written. Now would be the time to revisit those NDAs and revise them as appropriate. Tailor them a little more narrowly in a way that may help your employers to enforce them should the need arise. Strategy 4, review and update your non-solicits. Some employment agreements only have non-competes, but they don't have any prohibition on soliciting particular customers. The FTC was actually explicit that its ban doesn't cover non-solicits. So employers should take a close look at non-solicits. They have to meet the same reasonableness standards as non-competes in most jurisdictions, but they can be a very useful tool. Strategy 5, update policies and procedures. This is a good time to lock down trade secrets in general. If a key tool for protecting trade secrets is about to be taken away or is about to be limited and is going to be up for grabs, now is the time for employers to make sure they've got other measures in place to make sure that their information assets are protected. Recognizing that Most trade secrets are stolen by insiders. There's a lot of things that employers can do to help prevent trade secret theft when an employee leaves. Relatedly, employers can impose or update their security protocols. Again, focusing on internal threats. The external threats are important, but the internal threats are a very real, clear and present danger for many employers. Finally, number 7, trade secret owners, employers should have a crisis management plan. They should have it before the worst happens. They should enlist legal help, enlist your help, enlist technical help, computer forensic experts, IT professionals, and so on before theft happens. Promptly investigate, be ready to isolate and contain any loss, and to take swift legal action when something bad happens. And just as a bonus strategy, the FTC is now taking comments. Any member of the public can give comments on the FTC's proposal. Right now, the deadline is March 10th. That may or may not be extended. The FTC has a 200-page paper where it raises issues and gives the basis for its proposed ban. That'd be a great thing to address. And this is true for whether you are sympathetic to the FTC's proposal or not. Now would be a great time to weigh in. The FTC is taking comments. Actually, just today they had a public forum, which was very interesting. You could access it online, and I listened to most of it. And they have stricken fear into the hearts of business owners. I'll tell you that just from listening to the forum today. Again, the bottom line for employers is that they should prepare now, because disruption in one shape or another is definitely coming to the world of non-competes. I have to conclude with a shameless plug for my podcast. Listen to the Litigation War Room, where I interview attorneys, great attorneys. Visit the website, find us on LinkedIn, find us on iTunes, and so on. Thank you very much.
Thank you very much, and thank you for having me here. Obviously, all the lawyers know way more about this topic than I do, but I can share with you my point of view. Now, on the issue of selecting an expert, of course, and I'm a financial damage expert, so I'm not an engineer, I'm not a health doctor expert, do damages and valuations. And I would say that in my experience going back to 1984, that the valuation and determination of damages in a lawsuit is very artistic. I've been in cases where somebody's at 0 and the other party's at 200 million. And they both sound like they know what they're doing. But to the issue of selecting an expert, number one is the timing as to when you would select an expert. If it's a financial valuation damage issue, you should just hire me and I'll tell you what to do. But earlier is better, not just because we get to charge more fees, but I've been in cases where certain things have happened that I might have done differently and advise the lawyer, whether it's questions for fact witnesses or whether it's a subpoena to parties involved in the lawsuit. And I go, well, did you subpoena this party? No. Did you ask this expert this question? No. So earlier is better. Obviously, there's a fee issue that we all need to be cognizant about. When you hire an expert, we're out of pocket, we're not contingent. We charge by the hour, and so I understand the fees matter. But I've been in a lot of cases where by bringing us in late, we missed opportunities that we could have otherwise covered if I had been in there earlier on subpoena documents, deposition of fact witnesses, et cetera. And so with respect to how you pick an expert, I can just give you my view of that. Started doing it in 1984. I remember that case very vividly. It was a bankruptcy testimony on valuation, and so that's how I kind of got in the business. I was in the business because I had a very litigious client that used bankruptcy as a tool to play with the unions, and so I was involved in a lot of union issues in court and valuation issues. But as far as the due diligence goes for an expert, I've seen a lot of things. I've seen some great experts. I've seen some horrible experts. And I would just recommend that, you try to get an expert that fits the circumstances. Obviously, the industry, in my experience, and my daughter went to U of M Law School. I said, how much time did you spend at U of M on selecting an expert? She said, I think 5 minutes. And so lawyers tend to focus on the resume. So if they get an airline case, oh, I want somebody, an expert in the airline industry, or an automotive case, or a high-tech case. So in a perfect world, the expert would have experience in the industry in question, but I would tell you that a really savvy, experienced expert really doesn't need that much experience in a particular industry to be a good expert. And what I've found is that lawyers spend most of their time looking at your experience in the industry versus looking at your experience on the stand. And very seldom do I get asked about, well, how'd your testimony go in this case, and how'd the cross-examination go? I rarely get that question. So I would encourage you, when you pick an expert, obviously looking at their resume and their credentials is very important, but I would also spend as much time on their ability to be an expert and how they've done. It's all about surviving cross-examination, because the direct outline is we practice, and so the only risk is cross-examination. And I rarely get asked about that, and I think you really should think about whether, when you pick an expert, you get their experience in trial and how they've done in cross-examination. The cost, the fees matter. The member of the litigation experts team matters. Any conflicting testimony you should look into. I will also tell you this, though. A savvy expert could say something completely different in a different case, and lawyers think, well, we'll get that person because they said the opposite in a prior case. But a savvy expert, you probably won't get that person, even though you might think you will. I'm not saying you don't get into it. So any conflicting testimony you should think about. Obviously, if they've had Dalbert problems, you should be concerned about that in selecting an expert. The industry fit, as I said, is important, and they might have some intel on the opposing expert. I know a lot of people who do this, since I've been doing it since 1984. I know a lot of people that do expert testimony, many of which are really not that qualified, but they still do it, and maybe they say it about me, who the hell knows. But those are issues I think that you should consider when evaluating an expert for a case. And again, I'm a financial damage expert, but it's still applicable to an engineer, or healthcare, other experts like that. It's still applicable guidelines I think you should consider.
Van, let me ask you a question that was super helpful, super insightful as someone who works with and selects and vets experts. Very insightful. Let me ask you a related question about selection. What are some red flags or warning signs that you haven't picked the right expert?
That's a really good question. Warning flags would be, one, have they really done it before? I mean, when you could say, well, you're just having a discussion, but if you're in federal court on a $200 million matter and that person's not been in front of a jury before, you're really banking the farm on somebody that's a rookie winning the case. So I would look at experience. I would look into. I was involved in a huge case once for a national law firm, and they spent about $50,000 evaluating the accuracy of my resume. And I remember they told me, well, but the question really is this: when asked, is your resume accurate? My answer is it's accurate, subject to whether I missed a fee on some organization that I joined. Because they told me, well, you're no longer a member of Detroit Economic Club. Well, I forgot to make the annual payment. But as far as my credentials go and my evaluation, my certifications, and my education, there can't be any flaw whatsoever in any of that. And I think it's important that if you have a valuation case, that your expert have certification in evaluation. If you have a fraud case, it's important to have a certification in fraud. So there's a lot of certifications out there. I've got so many I look silly, but in front of a jury, probably more than a judge in a bench trial, I think that those credentials can matter when you pick an expert. So there you have it.
Thank you, Van. Another question, and by the way, time permitting, we'll leave a little time for Q&A. So if you have any questions for Van on the subject of selecting or using an expert witness effectively, I'd encourage you to ask him. But let me transition to kind of the second part, which is making the best use of an expert. What are some things that lawyers can do to make sure they make the best use of an expert that they have retained, whether it's a damages expert, forensic expert, technical expert, industry expert, what have you? What are some steps, or is there kind of a checklist that attorneys can use to make sure they're really maximizing the value of the expert services that they've obtained or that they want to obtain?
Thank you. It's a very good question. Look, when we're in a lawsuit, we always got to look at the cost value equation to make sure that the fees that make sense for the matter at hand and the quantification of the issues. So I get called in some matters, and I probably tell them, look, $500,000, $1 million matter, probably can't afford me. You'll lose more money with me than you will winning the lawsuit. But the key thing is, in my opinion, the key thing, and this is where and we're going to talk a little bit, I think, shortly about some real life examples, but the best way to use an expert is to, when we're involved in a case and we can give questions for fact witnesses, we can supplement the subpoenas, because there's certain kind of wording in my world as a CPA that you might have a subpoena and not use the right words, and you won't get the right document. And so utilization of your expert for subpoena, discovery, and questions for fact witnesses that are related to the expert testimony, but if we get hired late in the case and we've kind of missed that opportunity, and I'll say, well, did you subpoena the bank? No, we didn't do that. Well, of course, we all know that companies will really give the greatest projection, most optimistic projection to their lender. So they might be saying something different in the lawsuit, but yet they said something else to their lender. So that's an example where maybe a lawyer wouldn't necessarily think of that. And so what we try to do is supplement the discovery process with questions for fact witnesses and subpoena requests for documents and questions that really are related to our knowledge of the particular issue that a lawyer might not always know. And it's not saying lawyers wouldn't know it. I'm just saying that the earlier we're involved in a case now, and the earlier we're involved, and you can't go back and depose somebody. Go, did you ask them this question? No. Well, okay. And did you ask for this document from this third party? No. So I think the best use of an expert is to hire them as early as you can afford to hire them, because there's fees, and then use that expert, obviously for the expert opinion ultimately, but for questions for fact witnesses, questions for the opposing expert, and supplement subpoenas for parties that are necessary for the conclusions we want to reach.
Van, relatedly, we've been talking about best practices for using an expert. Well, let's talk about worst practices. What are some things that a lawyer should avoid, or there are landmines that a lawyer should watch out for as that lawyer works with an expert throughout the course of a litigation and in trial?
Well, there's experts and there's experts. And I met a guy in 1990 in a bankruptcy litigation out of Chicago. And this guy was the real deal. I mean, if he has 2 and 2 is 5, you need to leave him alone. You hand him a calculator, and he's got 2 and 2 is 5 on page 27. When he's done with you, the jury will think 2 and 2 is 5. So there's two kinds of experts. There's highly qualified, seasoned experts, and then there's experts trying to become that seasoned expert. And the way you deal with those two types of experts is differently. You don't want to spend a lot of time with a savvy expert, because you're in their field of study. They've been on the stand many times. They're used to all the trick questions. I've heard every trick question that anybody could ever imagine, almost 40 years of doing this. On the other hand, if you have an inexperienced expert, then you can spend more time and hope they say something that really discredits them or really impacts the outcome of the case. But I find, in my experience, when I'm tendered for cross-examination, that lawyers, I don't look at this wrong. I mean, I work with all lawyers, so I don't want anybody to take it the wrong way, but they feel a need to spend a lot of time on cross. And I would highly recommend that if you face a seasoned expert, you need to go in with a rifle approach, not a shotgun. Because if you spend enough time with a seasoned expert, you're going to end up going backwards. The whole point of cross-examination And the whole point of a voir dire is to get the jury to believe that either the expert is not as credible as opposing counsel tendered such expert as, and the opinions are questionable. But if after your cross-examination or your voir dire, the jury thinks the expert's smarter, then you wasted a lot of time. And so I would recommend a twofold approach. Seize an expert, go in with a rifle, get your expert to say the opposite, but don't try to win the case on a cross-examination of a seasoned expert. On an expert that's not that qualified or seasoned, you spend some time on him. I had a case in bankruptcy court where this lawyer spent all day with me, and to the point where the judge actually said to the lawyer, quote, "Haven't you had enough?" And so, you know, it comes down to what you think you can get out of the expert, and then if you really can't get it, put up your own expert who looks and sounds like their expert but says something different.
Thank you, Van. In a moment, I'm going to turn the mic over for any questions that anyone may have. But Van, let me just ask you, what is the most important thing, the biggest thing that you want lawyers to know when they are selecting and working with an expert?
Look, when we're in a case, we always have fees, and the client has to pay, and there's always an issue of how much it's going to cost. So we always have to be cognizant about that. But I would highly encourage you in a case of substance that you basically do a quasi-mock trial on your expert. And put your expert through just an interview. What would you say about this? What do you think about this? Because a real savvy expert, you really need to leave alone. You can't win the case with you win the case through your expert, but you know, it depends what you have. And I found that lawyers, when you get into it like a valuation and discounted cash flow, I mean, the lawyer's not going to know as much as the expert. And so you guys got to be careful how much time you spend with that expert. And so there's a variety of things that can happen. Take a voir dire, for example. When the expert gets tendered to opposing counsel, and you have an opportunity to question their credentials, you got to decide what you're going to do, because I know the book says, well, you need to voir dire and really kind of diminish their credentials that they just heard from opposing counsel. But if in fact when you're done, if that expert's smarter, you kind of went backwards. So you really got to decide on a voir dire. Maybe you stipulate. You just say, okay, I'm good with that, tender as an expert, and then proceed with your cross at that time. Because I've seen voir dire of savvy experts go backwards on the lawyers, even though I got to voir dire them on their credentials. And again, it gets down to, is the expert been up there, done this a lot? And if they have, you really got to go in with a rifle. For certain, the expert that I met in 1990, I would stipulate. Tender the expert, stipulates. An expert, move on, try to win it through your cross and your own expert.
Well, we have enough time for a question or two for Van Conway. Does anyone have any questions for effectively selecting or using an expert witness? Yes, here, take the mic. Feel like Oprah.
So Van, one question that I think a lot of us wrestle with is, if you're an expert who's, you've been around a while, I don't just mean you personally, but any expert who's been in the field for a while has done both sides of issues. And one of the real concerns, I think, is the tension between different positions you've taken. How do you, as a testifying expert, keeping in mind that you're in the game for a long time, balance, recognizing everything you do is going to be well-founded, of course, we know that. But when you're hired by defense, you're hired by plaintiffs, do you have a concern about the, taking positions that could be inconsistent or that are going to lead to impeachment and cross-examination?
Thank you, Mr. Steiger. He's a great lawyer, by the way. We had a famous case down in St. Croix. When you get into savvy experts, you got to be careful as to how far you go, and you want to do the best you can. But if you run across a savvy expert, you're going to win it through your expert. You're not going to win it through a cross-examination. And now, Mr. Steiger and I had a case in the 90s in federal court in St. Croix, and on the issue of selecting an expert, they hired somebody on paper which would be the perfect expert. What's that in St. Croix, which, by the way, nobody goes to. It's a miserable island in the Caribbean, which I almost got mugged at. But they hired the president of the CPA Association for St. Croix. Okay, we got a trial in St. Croix, and the guy probably knows all the jurors, be the perfect expert. There's the problem. He was a horrible expert. And so, you know, on paper, somebody might look like a great expert, but if they really had experience doing this, and we had a good outcome down there, mainly because John and Pat McCarthy are great lawyers, but when you go to hire an expert, if you find yourself with the wrong expert late in the case, it's kind of too late, and you know the boat's kind of sailing. In this case, I don't know how they did it, but they realized their expert was horrible, and they inserted me. I don't know how they did that, but they did, and it was really a rough dynamic in that lawsuit, but we ultimately prevailed, which is kind of shocking. I think it's because of Steiger's qualifications, a great litigator. But it's a real story to be told there about how to select an expert and the pitfalls of good ones and bad ones.
Thank you very much, and thank you for the question. Please join me in thanking Van Conway. I'm sure Van would be available for questions if you want to approach him afterwards. Thanks very much.
Okay, welcome to the highly anticipated discussion, the Judicial Perspective. So tonight we're going to be tossing some questions at a panel of 3 judges. We have the Honorable David Allen, the Honorable Victoria Valentine, and the Honorable Alita Popke with us here tonight. So judges, our first question of the evening is, you've sat on 2 benches, civil and business, and the business courts have been in business, so to speak, for about a decade now. With the aim of giving special attention to special cases, how do you think it's worked out? Who'd like to go first?
Lita, you want to grab that?
Well, I would rather defer to you and Judge Valentine since I've been off the bench now for a while.
We have a follow-up for Judge Popke. So let's start with Judge Allen. How have the business courts been working out? What do you think?
I think the business, well, this is really hard because there's so much feedback from everybody out there, but I think the business courts have worked out well. I think Wayne County has a little special challenge insofar as your business court cases compete with the 500 or 600 other auto accident no-fault cases I have. But absent that, I do believe we move cases quicker than in the past, but it just takes a little bit more management, if you will, in Wayne County with all of the other non-business court cases that we have.
Judge Valentine?
I think it's working out really well. We do not have additional civil cases. We have the business court cases, and then we have the criminal cases. The business court cases obviously have less priority if it's a trial. Our criminal cases that are capital cases go first, and then if they're in custody, they go second. But it's managed pretty well so far. I'm up for any suggestions that people have to make it run smoother. So if anyone wants to let me know how you think that we can do things better, I'm all ears.
And Judge Popke, now that you've moved into your role as a mediator, how can mediators help judges with the challenges they face running a business court docket? Thank you very much, Judge Popke. So I'd like to start this next question with Judge Valentine, if we could. Judge Valentine, you took over a very substantial business court docket last summer. What did you learn in the transition process?
Well, I learned how to manage a very heavy docket. We did a roundtable when I first took the bench with the lawyers. I think we had about 134 lawyers that were in attendance, and we kind of brainstormed how to make it better and work better for the business court, for the litigants as well as the attorneys. So we put a lot of that into play, and we reduced the amount of time that goes between cases so that they can get in quicker. You can have a status conference whenever you want. You just click on the docket, you call my staff, you ask to be added. And I think it really helps when you're interactive with the attorneys with the cases and allow them to come in when they can to kind of manage the docket. So we had a lot of summary dispositions that were up. I think now we're pretty caught up on everything. You can file your summary disposition, follow the court rules, and get the case heard. And hopefully you guys are seeing since we're past COVID, some good progress on your end as well. So that's what I learned.
Thank you. And if we could start with Judge Popke and then move to Judge Allen. Judge Popke, have you had a similar experience in times of transition, for example, between being a judge and then moving to your role at JAMS? Well, to that I'll say thank you, Lita. Judge Allen, have you had any similar transition experiences you can talk about?
So by the time I came to the business court docket, I had already been a judge for 15 years. I had handled a general civil docket. So the transition was a little less intense. When my law practice, I had some business litigation. So I had understanding of process, procedure. But the best thing that I ever did in the transition is I convened about a dozen lawyers at the DAC, leaders in the business law section, some of whom are in this room. And before I started that docket, I sat down and had a frank conversation with them about expectations, best practices, what other judges did in other jurisdictions. It's really kept me in good stead. And I want to say this. We as judges, we're here to serve you, not the other way around. You're our customers. Your clients are our customers, if you will. And for us to serve you, we have to have feedback as to what our best practice is. How are we doing? Does my clerk answer the phone? Are your orders getting signed on time? And I know, lawyers don't want to come up and tell the judge, hey, your clerk's not answering the phone, but we have to have a mechanism for feedback so that we can better serve you better have processes in place to move your cases along. So I'm still learning. I'm still in transition. I welcome all the feedback I can get.
Thank you, Judge Allen. So our next question, let's talk about clerks. One thing that lawyers seem to be curious about is, what does the judge know about the case versus what do the clerks know? And who are we communicating with at different times in the case? Of course, it's clear when we're on the record, but when we're writing briefs, dispositive or non-dispositive, who really is our audience? And this is directed at our sitting judges and our retired judges, because I know she has the tea. So who wants to start? Go ahead, Judge Valentine.
So I'm your audience. I'm the one who is going to read the briefs, and my signature is going on the opinion. So if you think that there's someone who's not looking at it, I assure you the judges work really, really hard. We do have research attorneys and staff attorneys that we direct to projects, but the judges ultimately are the ones who are reading the briefs and making sure the opinions are appropriate.
Much like Judge Valentine, I am your audience. And let me remind all of you of something I know you all know, but you have chosen to practice in a state court. I won't speak to Oakland County, but Wayne County, as I stated before, you're competing with lots of other cases. This isn't the federal court where I have 2 or 3 law clerks. I have a magistrate judge clerks. I'm it. And I have a law clerk who is also an administrative assistant as well. So when you're writing those briefs, when you're arguing, it's me. I read it. I read your footnotes. What does that mean in practical terms to you, litigating in front of me at least in state court? You got to get to the point. You have to be efficient. You can write a 100-page brief. I don't care. You got to build a client, establish your record, do whatever you got to do. But I'm quitting after 20 pages. And if you haven't gotten me to the point in 2 or 3 pages, I'm going to read your opposing counsel's brief first, because they're probably going to get me to the real point. So your briefing needs to have, I don't care what you call it, executive summary, introduction, roadmap, but I need to have in the first couple of pages what I probably can take and modify and slap opinion and order on the top of it. That's how I think you write your briefs in front of me. Those first couple of pages, get me to the point, and then again, you can take 20 pages, 100 pages, say whatever else you want to say, but get to the point and be efficient. I'm your audience.
Thank you, Judge Allen. Judge Popke, how does your knowledge of what goes on behind the scenes in this regard help you as a mediator? Thank you, Judge Popke. Our next topic is informality. With the pandemic, remote practice, the business courts, and digital communication, how have the judges here on this panel found this to help or hinder the practice? For example, some judges invite telephone calls to chambers before motions. And I know no judge likes the call during a deposition to resolve an objection. But in terms of that kind of communication, how do we feel about that? Perhaps we could start with Judge Allen this time.
I am fairly informal. I probably run a looser ship than most of my colleagues. I think Bernie Fuse over here will talk to you about that because Bernie Fuse had an emergency TRO this afternoon, and Bernie Fuse didn't have to go through jump a bunch of hoops to get to Judge Allen. Judge Allen called Bernie Fuse. Bernie? And of course, we had to get the other attorneys on the line, one of which was in Mexico, but I didn't want to have to deal with it over the weekend, so I figured I'm going right to the source. That's me. Obviously, you can't do that on every case. The case Bernie has some, what does it have, Bernie? It's got a lot to it, so I want to stay on top of it. I'm a proponent of Zoom, okay? I'm not dragging you down for the motion to compel or the motion to adjourn. When you need to come down, let me know to come down for the settlement conference. I'll be there. Obviously, we're going to try cases in person, but I just don't know that the motion practice, the run-of-the-mill, I'm going to have you back in the courtroom. There are some summary disposition motions that I think merit being in the courtroom, but it's a case by case, and I'm going to listen to my customers, you. Judge, we need to have this in person. That's fine. Short of that, I'll do it by Zoom. Yeah, that's it. Zoom and informality.
Thank you, Judge Allen. And in the interest of the fact that we have quite a few questions left, I'm going to push on actually to the next question, and I'm going to direct this one at Judge Valentine. So sometimes, very rarely of course, we find ourselves waiting a long time for an order or a motion to be processed. And as attorneys, sometimes we don't like to, shall we say, step on toes and call up and inquire, where's my decision? But Judge Valentine, should we do that?
Absolutely. We have, in Oakland County, we have new IT that's in place. We also have clerks. We have the clerk's office. There's a lot of things that can have a glitch. It could get kicked back from your own email. There's a lot of times that we won't see it. If you don't have an order back from me in 48 hours, which is a long time, in my opinion, you need to check on it because my orders get through every day. There is a problem that if you're filing something, it still has to go to the clerk's office, up to my clerk, to me, back to my clerk, back down to the clerk's office. So there's a lot of steps that go from when you file something to when it gets to me, but it shouldn't be. My turnaround time is really fast, so if you don't see it, definitely call.
Thank you, Judge Valentine. That was a clear and fantastic answer that we should all memorize, actually. So, Judge Popke, I'd like to direct this next one at you. What was it like being a judge versus an attorney versus now being a mediator? What are the biggest differences, if you will? Thank you, Judge Popke. I would like to pick on Judge Allen for this next one. Judge Allen, what tends to be your last straw? Meaning, what is it that a lawyer can do which really, shall we say, upsets the process?
Oh, I got a lot of last straws, but let me talk about one last straw. Look, folks, I'm paid to take the toughness of the process. My staff isn't. Don't disrespect the staff. My law clerk, my clerk, they're my family. We're family. You know, you say what you will to me. I got thick skin. But my last straw is when I get notice from my clerk or law clerk that they got a nasty call or a nasty email. It's just not necessary. You want to get huffy and puffy with me on the record, I'm going to take it in stride, but I'm not going to take it in stride somebody disrespecting my staff.
Judge Valentine, you're on the hot seat. What's your last straw?
My last straw is attorneys that try to set the other attorneys up for malpractice. Don't do it. Don't do it. We're all in this profession. It's a hard profession. That is my absolute last straw. I find that some people think it's a tactical way of winning a case or strategic, and it's really not at all. So think about that before you try it in my court.
Judge Popke, in terms of a mediation, is there a point at which you feel that it's a last straw situation and it's just not going to work? What do you think? Thank you, Judge Popke. Moving smoothly from the last straw to sanctions. I'd like to pick on Judge Valentine to start this one off. The American system is adverse to them, so sanctions should be used somewhat sparingly, but Judge Valentine, when are they appropriate?
I think they're appropriate in a lot of situations. Obviously, if there's a violation of the court rules under 1109, I think they're appropriate. If you have people filing documents that are not consistent with being honest or being fruitful, I think that that's a good reason to have the sanctions. And a lot of times, if we have sanctions and statutes, obviously that's appropriate. When I was on the family court bench, there was always the sanctions that were available. So I think that worked a lot in the family cases. In the civil cases, we used to have the case evaluation sanctions that we no longer have. So really, we're kind of losing hammers, and you do have to look to the court rules to see if there's a violation or something, even under 2313, if it's for discovery. And the judges need to enforce them so that we can ensure that everyone's playing on a fair field. So.
Thank you, Judge Valentine. So again, in the interest of time, I'm going to push forward to the next question, and I'd like to pick on Judge Allen for this one. The topic is changing your mind. Abraham Lincoln once said that he considered every judge was going to rule against him when he walked into the court, and it was his job to change the judge's mind. Judge Allen, how easy is it to change your mind?
Ask my wife. Yeah, of course I change my mind, but I read the briefs beforehand. I would not be telling the truth if I didn't tell you I come into a hearing generally knowing which direction I'm going to head, but that doesn't mean with the questions I ask that may give you some clue as to questions I have and give you an ability to change my mind. I always read for the facts. The facts drive the law, not the other way around. So if I've got your facts wrong, I think that's your avenue to convince me that perhaps I'm headed down the wrong legal path. So to me, an oral argument, you want to make sure that I've got the facts right. And I think that's a way in which my mind has changed all the time. Because you know your facts better than I do. I don't study every brief and have the facts wrote down. So anyway, yeah, my mind gets changed.
Thank you, Judge Allen. Judge Popke, flipping the script on that question, as a mediator, oftentimes you have to work hard to change the minds of the parties you're working with. What kind of preparation goes into your work as a mediator, and how do you change people's minds to come to a mutual resolution? Not too long at all. Judge Popke, we appreciate your response. Now we're going to move into the very dangerous portion of the evening. I have more pre-prepared questions, but I would much rather pick on a brave soul in the audience to ask the judges a question if anybody has one. Is there any brave soul who would like to step up? Aha, we have a taker.
All right, well, this is a question for either Judge Valentine or Judge Allen. I'm curious when a party files a motion under MCR 2.116C10 prior to the close of discovery, you probably see C8s early on frequently, obviously, but a C10 early on, what's your gut reaction?
Well, it doesn't have to be my gut reaction. It's usually the response, and the response generally says discovery is not closed. So, giving everyone the benefit of the doubt and looking at it in light most favorable to the non-moving party, I generally want to wait till discovery's over so that I don't have to rehear the case from the Court of Appeals.
All right, do we have any other questions from the audience? Bueller, Ferris, anyone? Aha! Got a taker.
Hi, Lee Moss. I had an unusual situation which I haven't seen in my 25 plus years of practice. I have a client who passed away, filed a notice of death, and after the notice of death was filed, my opposing counsel served interrogatories, admissions, and requests to produce. What's your reaction to that?
Don't you need to open an estate and have someone?
Family's not opening an estate.
Okay, and it's a personal case?
It's against a business and the individual owner.
Well, who else runs a business? Anybody? Who's a stockholder? A stockholder, LLC? What is it?
Stockholder passed away.
So a single stockholder?
Mm-hmm.
How do they want to continue to litigate it?
My opposing counsel apparently wants to litigate against my deceased client, but I wonder if you might allow the discovery to stand against the business, and if it isn't answered, enter a judgment against the business.
Well, who would be signing them?
No one to sign them.
What? I don't. I think you need to consult with the lawyers. Are there any lawyers in the room?
I just wonder if the judge will, a judge would allow a judgment against the business if they don't respond to the admissions.
You're wondering if a judge will do what?
Allow a judgment to be entered against the business for failure to respond to the interrogatories or admissions.
Bring a motion.
My opposing counsel.
They should bring a motion.
That's.
See what the case law is.
Bring your motion. All right, I think we might have time for one more question if there's any other question from the audience. Otherwise, I think we're ready for the next set of panelists. Okay, so introducing up next, and before I do that, thank you, Judge Allen, Judge Valentine, and Judge Popke. Amazing job. Thank you so much.
I'm Mark Rossman, and I'm here with Paul Go ahead.
Paul Mercino, Butts Along.
And what do you do over at Butts Along?
Oh, I do a little bit of everything. Starting a month from now, though, I will be taking the reins from Justin Klimko, who's been our able leader for the last 12 years, and I'll be taking over as president and CEO 1 month from today.
Okay, so you're basically in charge over there?
Well, my boss for the next month is still here, so
okay.
He's still in charge for now. But yeah, I got a great team around me, great board of directors. Bernie Foos is helping me out, great C-suite. But yeah, we got a great team, and I'm looking forward to being a part of it.
Well, talk to me about the transition and how long Justin has been there and what you're doing to manage you coming and taking over the reins.
So Justin's been there for 12, almost 13 years. The good news is he's leaving a very healthy company behind him. So I got it easy. I'm stepping in, things are going well, we're growing. The firm's doing very well. He's put a great team together. We've worked together for the last several years. I've been on our board for the last 3 or 4 years. So got a great team there, great firm, and I think as long as I don't mess it up, things will continue that way.
All right, so you're walking into this turnkey operation. and you guys are expanding out into Grand Rapids. So obviously you've made a decision to expand the footprint. So tell me what's going on in Grand Rapids.
Yeah, so we just, January 1st, we opened our doors in Grand Rapids. We've got 4 or 5 attorneys there, along with 2 paralegals. We wasn't technically legally a merger, but we joined with a bunch of attorneys from the law firm Silver and Van Essen. Some of the most respected attorneys in Grand Rapids, and they have been a great addition. They've really hit the ground running. First, we were looking for great people, and they fit that bill. Then we're looking for great attorneys. They absolutely fit that bill. And they do a lot of the same work we do from the litigation side of things, and they're very good at it. What we offered them was a platform for them to cross-sell and grow even more. And so far, it's only a month and a half in, but we love the city of Grand Rapids. We love being out there, and our new partners out there have just been fantastic.
All right, so you're managing a law firm. You're going to step up the management of the law firm, and you're also a commercial litigator, right?
That's right. Well, you and I met on the opposite side of the V from one another.
That's right, we did.
You were pretty nice, though. You were good.
You were too.
Good.
That's why we're friends now.
That's right. It can happen.
So here's a question that I always struggle with, or the answer is what I struggle with. The question I have in my mind. But how does a lawyer who manages a law firm do the lawyer's work? Which comes first? Which comes second? And if it's not in order, how do we do both at the same time?
That's really tough, and I'm interested in what you think, because you've been running a law firm a lot longer than me. It is a struggle. What I think, much like you, I worked with you and Linda. You got to surround yourself with really good people. And I used to be kind of a go-it-alone litigator. I like to just do my own thing. As I got busier, I'd bring associates in for little spot work. What I'm finding now is I've got to have someone, right-hand person from day one, by my side who knows the facts as well as I do or better, knows the case as well as I do or better. Because when things blow up, you're right, you're torn between two things. But what you can't do is tell the business you're running, hey, I'm going to be out for the next week taking care of fires. So I think the natural instinct for a really good attorney is the client always comes first. I think I have a duty, though, to my shareholders that the firm has to maybe come first. So that's why I have to have someone else by my side who can handle those fires when they blow up in a case. But what about you?
Yeah, so that's exactly it. You got to surround yourself with incredible people, which kind of begs another question is, how do you find those people and how do you keep those people?
It's tough, especially these days. These last couple of years have been crazy in the market. It's been a hot, employee market, if you will. The arms race with the compensation's been crazy. You try to differentiate yourself. Obviously, compensation is always important. You try to pay well. I'd like to think we've got a very good culture. We've been ranked best places to work in Cranes the last couple of years. I think you can feel it when you come in that we actually like to work together, and that differentiates yourself. But it's just a constant grind, because every time you bring in someone in, there's natural attrition. Other firms are trying to steal your people just as much as you're trying to hire their people. So it's a constant grind, but I think the one thing you can't fake, even through an interview process, is the culture and the relationship of the people who work together at the firm. And I think that's one thing we do really well, and it shines through. We've been really successful in the last few years. We've added a lot of excellent attorneys. Actually, in the last year, I was just looking at the stats today, we've added 14 attorneys. And when you look at attorneys, paralegal staff, we've added almost 40 people in the last 12 months. So I think we're doing a good job of it, but it is a constant grind.
Okay. What would you describe as the 3 biggest challenges that law firms are facing right now? Some of the things that I thought of were personnel, acquisition and maintenance, competition, and the rates we charge and how much people want to pay.
Well, I'll just steal that answer. Those are all good. All of those are true. I think the personnel, a lot of what I just talked about, because just as much as you're trying to recruit people, you also want to retain people, and that's just, it's a constant battle, but I think it can be done. There's a lot of new things that have come up since the pandemic that we all lived through. More and more people are working remotely. Can you really consider yourself a firm if you're not working together side by side in the same building? It can be done. I think we're all facing it, and some people love it. It's also, there's positives from it. But that's a challenge. How do you mentor younger associates? How do you have team cohesiveness? How do you collaborate? So that's one of the new challenges that we're facing.
Yeah, so with the work from home concept, and obviously that's evolved over time, and the ideas and the thinking of it have changed, but in terms of the two M's, mentoring and monitoring, how do you mentor and how do you monitor? And does the monitoring of lawyers who aren't necessarily with you all the time involve some kind of objective metric? Or, I mean, how do you track that? Because I think there's a real risk of people who, they're coming out of a law school life where it was very virtual, and then they're stepping into a law firm life where they're maintaining the virtuality of it because they have to attract talent. And so I'm just curious, especially at a larger law firm, how it's monitored and how we mentor in that context.
No, great question. Something we had a board meeting today and we were talking about all of that. The mentoring, mentor-mentee part of it is very crucial. Both of us, I'm sure, learned working next to the people that mentored us, walking into their office, or they could walk into our office, bouncing things off each other, passing, red lines back and forth. It's a little trickier to do over Zoom or over the phone or over email. And even if you have the younger people in to be mentored, they're saying, well, some of the older attorneys aren't in, some of the more senior attorneys aren't in, so how can I get that mentoring if they're not here? It's a tricky piece. What we've done, and there's different ways to do it. We have not mandated any attendance for attorneys. We didn't before the pandemic. We don't see any reason to do so afterwards. It's also part of going back to recruiting and retention. Some people love that hybrid. They love working from home. So if all of a sudden you're mandating they come in and other firms aren't, is that putting you at a disadvantage? What we are doing, though, so we're not going to make any rules from the top down. Our board has not, and I don't think will, make any rules that you have to be in X number of days or you have to be in on these days. But we've asked our practice groups, we've asked our individual offices, we've asked our industry groups that kind of collaborate together for them to do so. In an organic way, have lunches, have your practice department meetings on site, and really encourage everyone to come in site. We find that food and booze always brings people in, so, right? Look at it here. So have people in for lunches, happy hours at the end of the day, things that aren't onerous or draconian, but they make people want to come in because we do work together better when we meet each other. And what I've also noticed is, it's one thing, Bernie and I have worked together for 15 years now. We're gonna be best friends whether we see each other or not. What about the new people who are coming in? They haven't made those connections yet. They haven't made those mentor-mentee connections. That's where it gets tricky as you add new people. So it's a challenge, but we work at it.
Well, what do you tell a new lawyer? Okay, because when I started out as a new lawyer, and you started out as a new lawyer, they probably gave you some files and told you to go figure it out. And then if it wasn't right, you'd hear about it. And it was sort of like you mentioned, I think you mentioned earlier, it's something referencing the isolated practice of law and how people practice alone. And I mean, so my question is, what is mentorship? Is it putting files on people and telling them to figure it out and having them stay awake all night and go through that like pain and that fire? Or is it like creating a team where there's collaboration and organization and multiple people involved? And then the hard part is managing it with a client who's willing to pay for sort of the mentorship team process, which I think is what drives a lot of the individual practice of law, which drives a lot of people not really like enjoying it very much because they're doing it alone.
No, you're absolutely right. And part of that monitoring, we're always looking at people's billable hours, cash receipts, collection realization, billing realization, all these stats. But you're right. The client doesn't want to pay for that young associate to learn on their dime. I hear about the old days when you could go to a deposition with 3 attorneys. Those days are long gone. To have a trial with 3 attorneys is even tough these days because the client doesn't want to bill for it. So Are you writing off time? Sometimes you have to do that to have that mentoring piece. Maybe you have, I even do if I have a younger associate, why don't we both go and we'll both split our time? So I'm only going to write down half my time and you're going to write down half yours, because I know that it's important for them. Otherwise, it's just going to be me going and they don't get to go. So it's all kind of holistic. You're monitoring all this stuff, but to do it right, it has to be that collaborative, that feedback, not just throwing someone and say, do this, teaching them why. Some of my best mentors were the type who would sit down with me. I hated it at first because they would take the red pen out, mark up your paper, dripping with red ink, have you sit next to them while they go through line by line, making you feel really silly doing it. But then I realized at one point, this person cares enough to take time out of their day to do this, and I learned a lot from it. So I think it's got to be that ladder that you suggested, the collaborative and working together.
Well, and that, you don't realize it till you're the one putting the red ink on the paper, that in some ways it can actually be harder to do that than actually receive it. Because actually you're getting a bunch of nice edits that you can just go clean up before you go home at the end of the evening. Where the guy who gave you the edits needs to worry about if you're ever going to quit your job. So I guess that would beg the question in terms of mentorship. How do you tell people when they've done something wrong, or they're not doing something right, or their viewpoint on it is wrong, and it based on the years you've been there? Because I find that a hard thing to do sometimes.
It is a really hard time, and whether it's mentor or mentee, whether it's management, working with our C-suite or our staff or whomever it is. There was a recent book out in the last couple of years that I really liked, and it's called Radical Candor. And the whole premise of the book is it's actually kinder to be really honest with people. And sometimes it's uncomfortable, sometimes it's hard as the person giving the advice, but is that meaner than letting somebody just flounder, continue to do the wrong thing, obviously not doing it right or not picking up? I mean, the argument of this book, and I agree with it, is it's actually kinder to jump right to the, nip it in the bud or jump right to the point. Doesn't mean you're cruel about it. Doesn't mean you don't give someone second chances. But I think just having that honesty, and it's more respectful, frankly, to say, look, these numbers aren't cutting it, or this work maybe wasn't quite what I was looking for. And you can use it as a teachable moment. But it's much more cruel, I think, to just say nothing. Sometimes you'll have a partner, he doesn't like the work the associate does, so he never works with them again, never says why, never teaches them why or her why, he just moves on to the next or whatever. I think it's much better for all of the mentors and the more senior people to actually sit down and say, here's what you did right, but also here's what you missed.
All right, I'm going to change the subject a little bit, and I was curious, how were you asked to become the CEO of Butzel, and why did you accept the position?
Well, Justin was smart enough to get out, and he's not going to look back, I think. No. Justin, actually, much of the credit goes to him. He set up a whole process with a search committee. You could be recommended by others, or you could throw your hat in the ring. And it was a very lengthy process. There's questionnaires, there's lengthy interviews, there's many steps along the way. So I threw my hat in the ring. I knew the other people who were also doing the same were very capable. I knew they would do a great job. It was just something I've always kind of been drawn to leadership. I like the business side of the firm. I like litigating too, but I like the business side of it. So it's something I enjoy, something I was drawn to, and kind of thought, if not me, then who? There was other very capable people who could have done it, but I was drawn to it. Somehow or another, they decided upon me. The search committee nominated me or recommended me to the board. Ultimately, the board accepted it. So that's how the process happened, and Justin was instrumental in putting that together. And Justin's always been very good about wanting to pass the reins to the next generation. And at some point, you get to the point where you're making decisions that are going to affect other people's lives more than your own. So that's kind of why he put the process in place. How exactly I rose to the fore, I guess I don't know for certain, but I look forward to it, and I look at it as servant leadership. I mean, I'm there to assist everyone else, and like I said, I got a great team that'll be doing it side by side just as instrumental as myself. So I'm looking forward to it.
In terms of leadership, do you view leadership as something that is sort of a premeditated endeavor where you think about it and you figure it out and you implement strategies? Or is it sort of a learn as you go kind of thing, trial by error, And if it's that, does it change at some point in time along the way where you have to become a little more first degree about it?
Yeah, these are good questions, Mark. I think it's a little bit of both. It's a little bit of like nature and nurture. Some people are just born for it. Some people run from it and don't want anything to do with it. I've always, whether it's been sports, other things growing up, always kind of, like I was always the captain of my sports teams for whatever reason. So I've always enjoyed it. I came from a family business, so my parents started businesses, ran businesses, owned them and ran them. So I kind of was in my blood a little bit. It's an interesting question because a lot of it, I think, has to be strategic, has to be thought out. You're always got to be looking not just what's happening today, what's going to happen next week, next year, next decade. But while you're doing that, there's an old saying, while you're making plans, God laughs. So while you're doing all that strategic thinking, fires are blowing up left and right, and sometimes you just got to move quickly. You have to trust your instincts. Circling back to what we said originally, trust the people around you. You've got people in these positions for a reason. And usually, depending on what happens, they might have more facts than you, more background with it. You've got to trust the people you put around you, too. So it's this constant dichotomy of trying to do the long-term thinking, trying to do the strategic thinking, but then daily things are blowing up and you got to handle them.
And so when you're running business, you have ups and you have downs. Like on minute by minute even. You can win a trial and then you can get a call from some client who doesn't want to pay $150 title search or whatever. So and then when you're running a law firm, you have a plethora of surprises on a day-by-day basis. So those ups and downs, how do you keep level, if you can?
Yeah, no, I think litigation prepares you nicely for that. I remember this day I wasn't a young associate anymore, but I was still younger in my career, and I went over to Wayne County and I had a motion for summary judgment or summary disposition, and I won it. The judge granted my motion. Case closed. My client was ecstatic. I thought I was the greatest attorney in the world. And I said, well, I got one more hearing downstairs. I got to go downstairs. And it was a minor, nothing hearing. And I went down there and the judge tore me apart, embarrassed me in front of the entire room. This associate I had brought with me who thought I was the greatest attorney ever. And I was like, what is going on here? And it was the most humbling experience. And it was so funny because in that 10 minutes, I went from feeling like the highest to the lowest, and that happens all the time in litigation. And usually it's not your fault or your reason why either direction. So you have to have a short memory, and I think that happens a lot in business. And actually, Justin, one of the things that I've always respected more than anything about him is whether it was the greatest, we beat budget by X dollars, or the lowest of we missed budget by X dollars, it was the same calm, steady leadership, knowing that it's going to come back up or it might come back down. Don't get too ahead of yourself. And again, usually, quite often, it's not you're not the greatest, and that's not the reason things went so well. And it wasn't your fault that things aren't going as well as you want them to now. So you've got to have that calm hand on the rudder. It's easier said than done sometimes, but it'll come back around.
Okay, so that kind of invokes this concept that we hear a lot about wellness. Okay, wellness. You got to be well. But you're a litigator. You're running law firms. You got a bunch of litigators. What do we do when we're running our business in order to feed in, to facilitate this concept of not just being a litigator who burns themselves out on those up and downs, but actually takes a little time? And how does the leadership of a law firm set that tone so that people don't feel guilty about taking a little time off between, New Year and the holidays and wondering why they're the only one in the office, kind of thing? What do we do to, make sure that people live their life so they can come in and win their cases?
Yeah, it's not easy because on the one hand, you're trying to push everyone, get the best numbers. It is a business. You're trying to increase your profit and do that for the shareholders. But you're right. I mean, people are humans, and you can sometimes see when people are burning out, and you get that new associate who they're going to bill 300 hours every month, for the rest of their career. And we've even told them, hey, it's okay if you take a break. It's okay. You don't have to sleep at the office. Actually, please don't. Go home. We don't want you sleeping here. Little things we've done around our office. We've got beautiful space. We just rebuilt our Detroit office and our Troy office, and it's gorgeous. It's really nicely done. There's common areas. There's always food out, always fresh fruit, and we try to have healthy food out. We've got sparkling water dispensers. We have fridges in all of our offices with beer and wine. Yep, beer and wine is always there. We've got really nice areas with just couches where people table. At the end of the day, we'll take beers over there and hang out. We've got a meditation room where anyone can go in there, whether it's because of religious observances or whatever reason, go in there and it's quiet and calm and they can have some privacy there. We have a mother's room for new mothers. Sometimes they have to pump while they're at work or things of that nature. They have a private space where they can do that. And then we try to do fun things. We have employee appreciation events throughout the months, or one every month. We're going to do a March Madness thing next month with drinks and brackets, things of that nature. And a lot of it too is just being understanding. Everyone's got different schedules. Some people have young kids at home. Some people have elderly parents at home. It's just that understanding. I've gotten a couple emails in the last couple months, someone saying, I have really serious health issues, but I want you to know it's not going to stop me from working at all. And my first response to them has been, work is the last thing for you to worry about. Don't worry about that. Please don't work while you're going through this if that's what you need. Some people do need the work. If that's their release, that's okay. But we're kind of ingrained in us. We've got to show management that we're not going to stop for a second. I think it's important to just respond, no, you should, and do what you need to do. And part of it is just, I think, leading by example. For better or for worse. I mean, I've got 5 kids at home. I'm not, I want to get to their baseball games. 5 boys. I coach their baseball games. I want to get home to see their stuff. So, I work very hard, but I have a certain schedule I keep, and I understand others are going to as well. Some people are there at 5 in the morning and they leave earlier. Some people come in late. So it comes back to the flexibility, allowing people to have their lives and their professions, and just being understanding about it. At the end of the day, we all have to get our job done. But if you're doing that, I don't care if you have to knock off early for a family event or something like that.
All right, Paul. Well, thank you very much. I appreciate you spending some time here tonight, and I'm looking forward to watching you crush it as the president of Butts Along.
Thank you, Mark. I appreciate it.
Right now, we're going to be diving into the topic of shareholder oppression, fiduciary duties, and key court decisions. So my name is Michelle Harrell. I'm from Madden Hauser's litigation department. And tonight we truly have the dream team here. And I'm not just kidding, because they literally wrote the books and litigated the court decisions that govern these doctrines and claims. So this is a once-in-a-lifetime thing. You've got all 4 of them here at the same time. So first we have Professor Douglas Mall. He came all the way from Texas to join us today. He's a Harvard Law grad. He's been a law professor at the University of Houston Law Center since 1997. He teaches in the areas of business organization, and he's written horn books and course books, and he has numerous law review articles. So if you want to learn about corporate oppression, look him up. We also have Ian Williamson. He's a partner at Mantis Honigman. He actively litigates these cases. He's a Wayne Law grad like me, and he has some of the largest settlements and verdicts in these areas, in these cases. He's also written numerous articles as well, so these are all authors up here and experts on this topic. Next, we have Dan Quick. He's a partner at Dickinson Wright. He's a well-known, excellent trial lawyer. He's past president of the Oakland County Bar Association, president-elect of the State Bar of Michigan, a longtime leader of the governing council of the litigation section of the American Bar Association. He's written notable works, including Michigan Business Torts and Michigan Court Rules Practice, which I have in my office and use all the time. And he's had several significant court victories. And then last but not least, we have Justin Klimko. He's a shareholder and president and CEO of Butts Along. He has expertise in the area of Michigan corporations, and it's extensive. I couldn't even put his whole bio on here. We'd be here all night. He is the past chair of the State Bar of Michigan Business Law Section. He taught for 5 years as the adjunct professor at the University of Detroit Mercy Law School. He lectures, he authors articles, and he actually was directly involved in the development of the Michigan Business Corporation Act, from which shareholder oppression sprung forth. So he's here today to also give us his expertise. So we have the best here tonight to speak on these topics. So I'm hoping that you can hear all of them because it's going to be fantastic. So first, I have Professor Mall. If you could please illuminate us. So in oppression cases, the starting point is the Michigan Shareholder Oppression Statute. So I'll let you take it from here.
Okay, thank you very much. And thanks everyone for inviting me back for another year. I always like coming here. We have this lovely venue. It's like being in one of the world's best opera houses with the small problem that you can't hear any of the music. But aside from that, so my role is we're going to have a roundtable on various issues related to the shareholder oppression doctrine as well as breach of fiduciary duty. It's very difficult to talk about the shareholder oppression doctrine unless you know something about, well, the shareholder oppression statute. And so my role is to quickly introduce the statute and then let's get into some of the issues. I like to say a plaintiff's lawyer once said to me that he wishes there was a cause of action called unfairness, so that he could just walk into court and say, what's happening to my client is unfair. And I would suggest to you all that Michigan, as well as a number of states, but Michigan is what we're talking about tonight, Michigan has two causes of action that are basically unfairness causes of action: oppression and breach of fiduciary duty. And so let's talk about oppression for a moment. This is the Michigan oppression statute, which you presumably cannot see at all, but it's section 450.1489, and I think I kind of broke it up so that maybe, okay, so I'm just going to paraphrase a couple of things here, but that'll give you a little foundation so we can start talking about these issues. 450.1489(1), a shareholder may bring an action, small pause. A number of states, you have to be a 20% shareholder. You have to have held your stock for a certain period of time. Notice none of that in Michigan. You just have to be a shareholder at the time you're bringing the action. May bring an action, ... to establish that the acts of the directors or those in control, so another small pause, your defendants here are the directors of the closely held corporation at issue, or those in control, so you can sue the controlling shareholder. In some situations, you probably can sue an officer, depending on sort of how the control dynamics work in that company. So you can sue the directors or those in control for their actions if they are illegal. That's not really our subject tonight. Fraudulent, not really our subject tonight. Or willfully unfair and oppressive, and that is our subject tonight. That is the oppression doctrine. That's the statutory basis for it. You can come into court and complain about willfully unfair and oppressive action. Notice, to the corporation, small pause, very unusual. I will tell you, I think Michigan's the only state that still has that. That came from South Carolina, which no longer, well, maybe they still have it. Oppression to the corporation, quite frankly, is a somewhat odd concept. But more importantly, it can be oppression to the corporation or to the shareholder. So you come into court as a shareholder, you complain there's been willfully unfair and oppressive conduct towards you or towards the company, although that's my personal view, slightly more unusual. Okay, there's various remedies that can be provided. The only one I want to point out to you very quickly is E. E is the purchase at fair value of the shares of a shareholder. So a buyout. You can get bought out at fair value, and we're going to be talking about fair value a little bit. Section 2 of the statute just says basically this is an action you can bring in a closely held corporation. If your company is publicly traded, you've got a market, you don't need a litigation resolution, you can just sell your stock on the market. 3, I want to pause on. 3, Michigan actually defines what do we mean by willfully unfair and oppressive conduct. And so you'll notice in 3, it means a continuing course of conduct or a significant action or series of actions that substantially interferes with the interests of a shareholder as a shareholder, which is an important point. In many jurisdictions, you can complain that you were harmed as an employee or as a director. In Michigan, you have to show that you were hurt as a shareholder. Is it possible that employment harms could hurt you as a shareholder? Well, the next sentence talks about this. Willfully unfair and oppressive conduct may include termination of employment, ... to the extent the actions interfere with distributions or other shareholder interests disproportionately. We're probably not going to talk about that issue tonight, but come back in 2024, where we probably will talk about that issue. Finally, the last sentence, which is an important one that we are going to talk about. which is Michigan, as well as a number of states, has a provision like this that says the term oppression, willfully unfair and oppressive conduct, doesn't include conduct or actions that are permitted by an agreement, the articles, the bylaws, or a consistently applied written corporate policy or procedure. The idea there is supposed to be, if you have agreed that certain types of conduct are permissible, you shouldn't be coming into court claiming that when those things happen, that it's oppressive. The idea is you've agreed to it. One other quick comment. Aside from this statutory oppression action, Michigan has tons of common law on breach of fiduciary duty, on directors and officers and controlling shareholders owing fiduciary duties to the company. And certainly for directors, the Michigan Supreme Court, in the case we're going to talk about this evening, Murphy, has made it very clear that those fiduciary duties are also owed to the shareholders. So think of both of these causes of action in your head as we proceed tonight with sort of a smattering of issues that come up in these areas.
Great. So thank you for that foundation for our discussion. Next, we have Ian Williamson. And certain key issues arise during oppression litigation. And the business rule is often implicated. And so Ian's going to address that, and there's also some other topics that seem to pop up in litigation.
Let's see if I can figure out how to get these slides back up for a minute here. This way?
I aimed it that way, it seemed to work.
Okay. There we go. All right, well, thank you for that great introduction, Professor Mall. My name is Ian Williamson. I'm a partner at Mantis Honigman. I've been litigating for about 20 years now, and during that period, I've had the luck to be able to litigate a number of cases that have been shareholder oppression cases, both with my current partner Gerard Mantis, my former partner Mark Rossman. We've litigated a lot of these matters, and one of the cases that I have spent a lot of time on in my career and that I wanted to follow up on with everyone tonight is a case called Franks v. Franks. This is a case that was originally filed back in, I think, 2013. This case wended its way through multiple different courts. We tried this case once in front of Judge Stutzman in St. Joseph County. That went up on appeal. That resulted in a Court of Appeals opinion that came down in 2019. This case went back up to trial again in Kent County in 2020, and we're still waiting to hear the final verdict on Franks now. But the Court of Appeals opinion in Franks that came down in 2020 or 2019 was one of the first published opinions interpreting the shareholder action statute that had come down in quite some time. For a statute that's been on the books for roughly 30 years now, it's a little surprising that there's a real paucity of published appellate decisions interpreting this statute. So when the Franks opinion came down, there were a lot of holdings that were very interesting at the time, a lot of analysis that we hadn't previously seen from appellate courts on the shareholder action statute. And I wanted to follow up on a couple of these holdings to see what, in the interim between 2019 and today, what has happened with the Franks opinion and with some of these different issues. And a couple of the issues I wanted to follow up on were the business judgment rule and the fair value analysis from the Franks opinion. Now, the business judgment rule, most of you all are probably familiar with this. This is a rule that says that courts are generally going to defer to the actions and decisions of corporate directors as long as those actions are not clearly taken in bad faith or are clear breaches of a fiduciary duty of loyalty. Before the Franks opinion, one common defense that we would see in shareholder oppression cases would be arguments that the actions of the directors could not be second-guessed by the courts because they were protected by the business judgment rule. What the Franks court clarified was that if you properly plead a case under the shareholder action statute, you have necessarily pled facts that take that claim outside of the protections of the business judgment rule. So when that holding came down, let's see if I can.
Want me to switch it for you? Go ahead.
There we go. When that holding came down, there was a lot of discussion within the bar about whether the Franks opinion had essentially killed the business judgment rule with respect to the shareholder action statute. And I wanted to follow up and see what the actual impact has been of the Franks opinion on business judgment rule arguments in shareholder oppression cases. And it's been a few years, and I was surprised to see that there has not really been as much analysis and citation of Franks on this issue as I would have expected. Shortly after the opinion came down, there were 3 cases decided all within a very short period of time in the summer of 2020. One was Smith v. Smith. This was a case that my firm was litigating in front of in the Eastern District of Michigan. And in the Smith v. Smith case, the business judgment rule was raised as a defense, and the judge, Judge Mark Goldsmith, cited back to Franks for the proposition that because of the Franks opinion, the defendants in that case could not avoid analysis of the entirety of the circumstances surrounding the director's decisions. In other words, the directors had to be subject to scrutiny. They could not protect their actions using the business judgment rule. That seemed to be pretty much in keeping with what the Franks court had determined, but another opinion that came down within about 6 weeks of the Smith v. Smith opinion was a little different, and I think we'll probably hear some more discussion of this later tonight. This one was MJC Ventures versus Detroit Trading, also in the Eastern District of Michigan. In this case, Judge Berg also cited to Franks and held that the business judgment rule did mandate dismissal of the plaintiff's suppression claim based on failure to pay dividends because there was no allegation, plausible or not, that the board's decision was motivated by fraud or bad faith. So we have in the Eastern District of Michigan, within a short period of time, 2 opinions, both citing to Franks, both analyzing the business judgment rule and shareholder action cases, but 2 pretty different outcomes here. The only other case that I have seen where Franks has been analyzed in looking at a business judgment rule defense since the Franks opinion came down was Spitler v. Spitler, which is a Livingston County opinion in front of Judge Geddes. And in that case, the issue was whether a receiver should be appointed. And one of the reasons why the plaintiff was seeking appointment of a receiver was because they alleged oppressive conduct had taken place, in part because dividends were not being issued. Judge Geddes, in that opinion, declined to appoint a receiver and held that the director's alleged oppressive refusal to issue a distribution was protected by the business judgment rule. So in that opinion, it seems almost a little counter to what Franks held. I don't think that there was ever any appeal. I don't think that that was followed up on. But again, we've got 3 different opinions, 3 different judges, 3 different interpretations. I think what these show is that to the extent that anyone thought that the Franks opinion killed the business judgment rule, that clearly hasn't happened. I think what the Franks opinion probably has done is established that if you want to avoid the business judgment rule on a C8 motion, you really need to be careful how you plead your case. If you do a good job pleading your shareholder action claim, you can probably avoid a C8 motion, but that doesn't mean that you can avoid the business judgment rule altogether. The other issue I wanted to follow up on with Franks was the fair value issue. This is one that I have seen litigated essentially throughout my career because one of the enumerated remedies for oppressive conduct, if you are able to establish to a court's satisfaction that oppressive conduct has taken place, is a buyout of the plaintiff's shares at fair value. That's what the statute says, fair value, but what the statute doesn't do is define fair value or tell you what the legislator meant when they said fair value. Unlike a lot of other states that have definitions of fair value directly written into their business corporation acts, we don't have that in Michigan. So there's been a lot of argument in Michigan about what fair value really means. Does it mean fair value in the accounting sense? Does it mean just a percentage of the going concern value of the entity without any discounts applied for minority shares or for lack of marketability? That's what a lot of plaintiffs have tended to argue. On the other hand, because we don't have specifics in our statute as to what fair value means in the oppression context, defendants have typically argued that you can and should apply discounts for marketability, for lack of control, discounts based on minority shareholding interests. because those are standard common discounts that are applied when you're doing an arm's length transaction. Now, the Franks Court clarified that, yes, fair value and fair market value are not the same thing. But the Franks Court further held that just because fair value and fair market value aren't the same thing, that doesn't mean that in Michigan we are going to completely prevent the application of discounts, whether it's for lack of marketability, whether it's for lack of control. The Franks Court looked back to Matagula v. Taub, which is another shareholder oppression case decided by the Supreme Court back in, I think, 2014. And in the Matagula case, the court held that our statute gives extremely broad authority to the trial court. And because that authority is so broad, the trial court can essentially do what it wants in crafting an appropriate remedy. And the Franks Court seized onto that and said, because this authority is so broad that the trial court has, if they want to look at a minority discount, they can look at a minority discount. If they want to apply the marketability discount and they think it's appropriate under the circumstances, they can do that. If they think no discounts are appropriate, that's also within the trial court's power to award a buyout with no discounts. But just because we use that fair value language in our statute, that doesn't mean that you cannot apply discounts if you're the court and you are awarding a remedy for oppressive conduct. So that sets us apart from a lot of other states, because a lot of states require that the term fair value be an undiscounted value. The only thing we have in Michigan that really speaks to fair value is a fair value definition in the dissenter's rights portion of our Business Corporation Act, and that definition doesn't really state for certainty that discounts can't be applied. So following up on the fair value analysis in Franks, I surprisingly found essentially no cases in Michigan, even at the business court level, that cited to Franks when it came to fair value. The only thing I found was one Connecticut case citing back to Franks for the proposition that fair value and fair market value aren't the same thing. But in that case, they have in their Business Corporation Act a specific definition of fair value that states that it's not discounted. So the takeaway from this, I think, is that Franks gave a little bit more clarification to this issue, but maybe it didn't really tell us much more than what we already knew, which was that under Matagula, the broad equitable powers that the trial court has really aren't limited. The statutory language is so broad that the judges can craft whatever remedy they think is appropriate, and the term fair value used in the statute doesn't really require the judges to do anything specific.
Okay, thank you very much. That was
Michelle.
a great discussion on fair value.
Can we throw in a comment or?
Well, we have 20 minutes left, so let's let Dan go. So next up is Dan Quick, and he's going to present to us on willfully unfair and oppressive conduct.
Okay, my honor to be here with all of you and this fine panel, and thank you all for sticking around. I'm here to talk to you about what I sometimes call the silver bullet provision of the statute. As you can see highlighted on the screen, the concept is that in the definition of oppression, that it cannot be willfully unfair and oppressive conduct if it is something that is permitted by an agreement, by articles of incorporation, the bylaws, etc. So if you were smart enough to write it into a corporate document somewhere and then exercise that power, sorry plaintiff, you're out of the box. How has this actually been applied? Well, the case that applies what I think is, at least at first blush, appears to be the most black and white application of this is the aforementioned MJC Ventures case, an unpublished E.D. Misch opinion. And the plaintiff alleged oppression, it was dismissed on 12b-6, and when you read the opinion, it seems very black and white. What the defendant was alleged to do was set forth in writing, therefore, sorry plaintiff, you're out of the box. The erstwhile plaintiff did not give up. They filed a motion to amend, and in a fourth amended complaint, tried to add some facts demonstrating that in fact this was oppressive conduct, that it was a squeeze out, that this person was being targeted, etc. And still the court said, no, not good enough. You failed to allege actions taken by the shareholders and the board were inconsistent with the Articles of Incorporation. So again, if you take that snippet out of context, it kind of sounds like the silver bullet defense. If it's in there, sorry plaintiff, you're out of the box. But that opinion goes on to discuss the Bromley opinion, which is another unpublished E.D. Misch opinion. And in that part of the discussion, the court does suggest that no, there's room to get around this argument. In other words, even if a power has been granted to the board, if they exercise it in bad faith or they do it to try to target the plaintiff, that can still possibly constitute a cause of action, but they just held plaintiff failed to plead it. Now, why should the plaintiff have to plead in such specificity? That's a discussion for another day. So what about in the Michigan Court of Appeals? One unpublished opinion, Berger versus Katz back in 2011, the greatest case for any plaintiff ever litigating a shareholder oppression case. It's their best case. And in this case, the court found exactly the opposite, that there were some activities alleged that to be wrongful. The plaintiff said they were oppressive. The defendant, of course, raised the silver bullet defense. And the court said, yeah, no, I think it's okay. Because it's being alleged that those powers were being exercised in an attempt to squeeze out the plaintiff. And here the court relied on the Bromley decision in part, which also talked about the fact that, well, maybe out of context, it looks like it's clearly authorized, but in context, the way they exercised it or the reason they exercised it was designed to screw over the plaintiff. So here you have the plaintiff's side, the best plaintiff opinion, unpublished versus unpublished. The court went on in this opinion, and this is the key language, saying although the bylaws gave the defendants the authority to make business decisions, this does not mean that they were permitted to act in a manner that was willfully unfair or oppressive to the plaintiff. So a couple issues here. One of the issues is a language issue. The bylaws gave the defendants the general authority. Well, what if it was specific authority? What if the thing that they were alleged to have done was specifically authorized in the bylaws? Could that still be oppressive when you're dealing with a statute that uses the word permitted? Fair question. The other question that this raises is how the statute is supposed to be interpreted, and are you really reading provisions into it? Again, the statutory language is, it does not include conduct permitted by an agreement. This seems to be going beyond permitted, saying, yeah, it's permitted, but the way they're taking the action or the reason they're taking the action somehow is relevant to the oppression claim. So these are open questions under the statute. Do we have other answers? Not really. There's a 2013 opinion from a New York federal court applying Michigan law, which, without a whole lot of analysis, relied upon Berger and let a plaintiff's claim survive an initial challenge. What about in the business courts? This varies, of course, but this is an opinion from 2018 in the Oakland County Circuit Court. Jim Alexander authored this opinion, and he sets up an analysis here that isn't really supported by any case law per se, but it's a pretty succinct summary if you wanted to try to capture the essence of Berger and put it into a statute. And says, look, first of all, it's typically a fact question, and those fact questions are whether the event occurred, and two, the motivation or intent of those in control in performing the complained of acts. So when you get all the way back to MJC Ventures, where I started, where some of the commentary around the motion to amend suggested that, yes, a claim may be proper here if you plead the sufficient facts, this sort of dichotomy or this sort of presentation of the elements would seem to support that. But there's lots of arguments to be made as to whether or not that's reading too much into the statute or whether it can really bear all of that weight based on the word permitted. So a number of questions arise from this whole silver bullet element of the statute. One is what we just talked about. What does the statute really mean? What was its intent when it was passed by the legislature? What does it mean for litigation strategies? Well, the takeaway from MJC is whatever you think about Federal Rule 8 and your specific pleading obligations, plead facts. Because if you plead facts and you plead context, you will stand a better chance of surviving that initial 12b6 motion. What about for the corporate lawyers out there? Drafting strategies. In a perfect world, you're going to try to be as specific as possible in your bylaws, in your articles of incorporation, in your operating agreements as to what the managing member can do, how they have sole discretion, et cetera, as strong as you can possibly make it and still get other people to sign it. Because as long as those provisions are in there and if you can make them as specific as possible, you're going to have a stronger argument should it ever come down to litigation. With that, I will pass it off to my good friend Justin.
Thank you. Thank you, Dan. So I am going to talk about, if I can get, okay, a case, Murphy versus Inman. This is a Michigan Supreme Court case that came down in April of 22. Now, two things about this case. Number one, it's not an oppression case. This is a case about fiduciary duty and shareholder rights to bring direct actions. The second thing, this is not a privately held business case. The corporation involved here was a publicly held company, but the holding in this case is applicable to all Michigan corporations, and it established a new and very important standard for determining when an action must be brought derivatively and when it can be brought directly. So what happened in this case? A publicly held corporation, Covisint, many of you may remember Covisint, was merged with a company called OpenText in a cash-out merger. What's a cash-out merger? That means the corporation was essentially sold. The shareholders of Covisint received cash for their shares, no continuing interest in the business. So when the dust settled, the shareholders had cash, but they had no interest in the surviving corporation. They sued the director saying, you sold too cheap, okay? You approved this transaction at an unfair price, and we wound up getting hurt by the fact that we received less than we should have for our shares. The defendants went into court and they said, hey, the shareholders cannot bring this claim. They brought it as a direct action. They did not follow the derivative rules, and this is a derivative case. And remember, the Michigan Business Corporation Act says, with respect to derivative actions, that before you can bring one, you have to first make a demand on the corporation, and you have to wait at least 90 days. And they hadn't done that. There was no dispute about that. So the defendant said, this is a derivative case, and therefore it should be dismissed. And the trial court dismissed it on those grounds. And the plaintiffs took an appeal up to the Michigan Court of Appeals, and the Michigan Court of Appeals also affirmed on that ground. It went up to the Michigan Supreme Court, and by the way, the business law section filed an amicus brief. Ian and I were both part of the team that put the brief together. Filed an amicus brief in this case. The Supreme Court unanimously overturned the ruling of the lower courts, and they said this case can proceed as a direct case. They obviously didn't decide the merits of the case, but they allowed procedurally the case to proceed as a direct action. So some very important things the Supreme Court said here. First thing it said was the directors have common law fiduciary duties to shareholders. One of the defendants' arguments was that there's a standard in the statute, in Section 541A of the Business Corporation Act, that describes how how directors must discharge their duties. And the defendant said that's exclusive now. That overruled and overwrote previous common law. And the Supreme Court said no. There's no evidence that in adopting the Business Corporation Act, the legislature intended to overrule or to abrogate common law. So there is a direct fiduciary duty of directors to shareholders, in addition to the duty that the directors owe the corporation itself. The second thing they said was in a cash-out merger, the directors' primary fiduciary duty is to get the best price possible. This follows a line of cases that started in Delaware back in the mid-'80s, a famous case out of Delaware called Revlon, that essentially said, look, once you've made the decision that you're going to sell the corporation to somebody, your only job is to get as much money as you can for your shareholders. There's no corporate interest to protect anymore. You're not going to be running the corporation anymore. You've got no strategy or policy to defend, so you just have to get the best price you can for the shareholders. Third thing, and this is maybe the most important thing that came out of this case, is the Supreme Court said that there's a new two-part test, which I'll discuss in a minute, for determining whether an action is direct or derivative. And I'll get on the next slide to what those tests are. But that changed. So the old law in Michigan sort of started with the premise that a suit against directors is a derivative suit. And then it went on to say, well, there's a couple exceptions that may allow it to proceed directly, but those exceptions are either the shareholder who is bringing the suit sustained damage different from what the other shareholders did, or that the directors breached a distinct duty owing to that shareholder, individual shareholder. And the fourth thing that the court said in this case was that a claim for breach of duties in a cash-out merger is a direct claim. It's not a derivative claim. Okay, so what's the new test? This test is taken from a Delaware case called Tooley versus Donaldson-Lufkin. The court said it's a simple test now. The test is who suffered the harm and who would benefit from the recovery. And this case was a great example. It said if the answer to both those questions are the corporation, then it's a derivative action. Otherwise, it can be brought as a direct action. And think about this particular case. Here you had shareholders saying, we have suffered because we had to sell our shares too cheaply. It would make no sense at all to say that's a derivative action, which would mean that the recovery would go to the corporation, right? Because the corporation was now owned by the alleged wrongdoer, the person who bought too cheaply, and any recovery would go to the corporation, and the shareholders who were complaining would be left without a remedy. And the Supreme Court said that makes no sense. And it said in the context of this analysis, the old rule doesn't make sense because it started with the premise that the action had to be derivative, and then it looked at whether either of the exceptions applied. And the Supreme Court said those exceptions may not have applied in this case, but that misses the point. The point is the threshold question is, should it be a derivative action to begin with? And that's why we now have this two-part test, which is, again, adopted in Delaware and a number of other states. If the person suffering the harm are the shareholders, it doesn't have to be a distinct injury different from the other shareholders. In this case, all of the shareholders suffered, all the public shareholders suffered the same fate, right? They all, in theory, at least allegedly, sold too cheaply. So using the exception doesn't make any sense. So the court now has instituted, this is now new Michigan law. Going forward, it's a much, much simpler test and a much more rational test for determining when a shareholder action can proceed directly as opposed to when it must be brought derivatively. How are we doing in time, Michelle? We got anything left?
Thank you. Yeah, this time is going so fast. Professor Mall, did you have something to add on fair value? I know you have a broad nationwide expertise.
Well, let me just say, I think every single one of the issues that we're talking about tonight are national issues. Fair value is unquestionably a national issue. Almost every state has either a statute or a judicial precedent if they have an oppression doctrine that says a buyout at fair value, and then they get into the question about what fair value means. I tend to agree with the comments that Ian made that it's was that you, Ian? I think it was you. Yes, that it's unusual that Michigan in Frank seemed to say fair value means no discounts. Well, but it depends on the circumstances, and so if you have good circumstances, I guess you can apply discounts. That is a very wishy-washy, strange result when you get out of Frank's. I will tell you that most states who have considered the issue have said fair value means no discounts, and that means no minority discount, no marketability discount, with the exception of New York, which for various reasons does apply a marketability discount, but not a minority discount. But Michigan seems to be on its own with the very no discounts, unless you come up with a good reason, then we'll talk about discounts.
Well, we have a couple of minutes left. Does anyone have any questions for the panel? Anyone? I know it's a pretty heavy topic.
I'd like to ask a question to the panel.
Oh, yeah, okay.
If someone would just amuse this Texas lawyer, why is a case unpublished in Michigan, particularly when it's directly on point to some of the issues we were talking about?
I should get a drink before answering that question. The short answer is what the Michigan Court of Appeals judges would tell you is they have a lot of cases. They can't give full bore treatment to every single one. And so for the half-baked ones that may not have all the rationale in there that they don't want to have precedential value, they issue them as unpublished. The reality is, especially in this area, the vast majority of cases we're forced to rely upon and try to argue to courts are unpublished.
You're allowed to argue them?
You're not as persuasive, I mean, not as controlling, but you can say, hey, judge, you ought to consider it as persuasive. Ian?
Yeah, we spend a lot of time arguing about unpublished opinions and why they should use our unpublished opinions as opposed to the other attorneys' unpublished opinions when we're litigating these cases. That's mainly what we've got.
Yeah, so if you have a really good appellate decision, you might want to consider making a motion for publication so that we get some real law that we can actually use. Okay. Any other questions? No? Okay. We're right on time. Thank you so much to this panel. You're wonderful.
Thank you, Michelle.
So now I'm here to talk about the art of cross-examination. And I'd like to start with, how did I learn how to cross-examine a witness? And I would say 3 ways. One is watching a great cross-examiner in action. I was very fortunate that in my first 8 years of practice, I got to try 6 major cases with Steve Wassinger, who is a superb trial lawyer and an outstanding cross-examiner. I would say that his style and approach is somewhat unconventional, but he's very smart. He has an aggressive, go right at the jugular approach to cross-examination. He has a presence with a commanding voice, with leading questions that back the witness right into a corner. And so I strongly urge everybody to watch really good cross-examiners in their craft and take from those great cross-examiners what you like, what you think is effective, and you incorporate that into your personality. The second thing is a wonderful textbook is Maut on trial practice. I first used that as a law student at Wayne State University. I used it extensively when I did my first few trials. I used it as my textbook when I taught trial practice at U of D Mercy. And to this day, when I go into a trial, I will skim through it just to refocus on the fundamentals of trial practice and cross-examination. Third, an oldie but goodie, Irving Younger's videos and 10 Commandments on cross-examination are outstanding. He tragically died at a relatively young age in 1988, but his videos are still available on YouTube, and I strongly encourage everybody to watch them. I completely agree with his philosophy of trial practice and cross-examination. Here's a small excerpt from one of his famous lectures. So I wholeheartedly agree with that. In fact, it's my policy and practice to have my opening statement game ready 30 days before trial, and I deliver it to lawyers within my firm for a critique. Same thing with the key cross-examination outlines. So these are what I see as the key elements to prepare for an excellent cross-examination. 1, what did the witness say in contemporaneous documents? These are always the key to every cross-examination and every trial. What did the key witnesses say before anybody lawyered up, when they were in the real world? And that's what jurors give the most weight to. That's a crucial tool for cross-examination, and you want those documents before you take the deposition of any deponent. The second element is, what did the witness say under oath in their deposition? That's the second crucial building block for cross-examination at trial. Third, you want to learn about the witness. Before and during the deposition, you make judgments about that witness. How honest is the witness? How smart is the witness? How well prepared is the witness? Because that will help you decide what risks you take in cross-examination at trial and how you frame your questions. Know before you take a single deposition what the jury instructions and verdict form will look like, and frame your questions around those instructions and verdict form. So it's that way in the deposition, it's that way in your opening statement, it's that way in your direct and cross-examinations, and in your closing argument. So when the jury then gets the instructions in the verdict form, the answers that you want are second nature to the jury, because they've heard it over and over again. I believe very strongly that you want to get the documents and study them before the deposition, not at the deposition. In my opinion, there is no such thing as a discovery deposition. You want to have a killer instinct. A discovery deposition is lazy and unproductive. Throughout my career, I have seen too many lawyers with a stack of documents at a deposition and just say, what does this mean? What does that mean? That's not effective. I believe a deposition is 75 to 80% getting admissions that are going to help you win the trial, and the other 15, 20, 25% is helping you understand things you really don't know. So there is a discovery element early in a trial, but you want to have a trial mentality from day one. And if you do, you're more likely to not go to trial because the other side knows they're dead and they're going to want to settle with you. But if you do go to trial, you will be exceedingly well prepared. I also believe that what you want to do is create a binder of segments. And what I mean by a binder of segments is I prepare a separate segment for every line of cross-examination, and I put at the top of each segment what the objective is for that line. So while when I'm in the battle, and I might get surprised by the witness, and I will go off my script, and I will take what the witness will give me, I want to make sure that I have not lost sight of the objective for that segment. And if you do that with every segment, you won't miss anything, and you will cover everything that you need to cover with that witness. Every question should use the precise words of the witness, whether in a contemporaneous document or a deposition transcript with page and line numbers. And I'll give you an example of how I do that from a recent trial. I will have right in my notes the exact question. And according to this chart, only one participant was able to reach reverse on the first attempt. Is that right? In that case, that was very, very important. Notice the precise language is exactly the words that were used by the witness in the deposition. I have in my segment the page number and the line number. So you're not flipping through a deposition transcript. It's right in your binder, right in your segment. The other thing I do is embed the document within the actual exhibit. So I have the exhibit number and I have the actual document interposed. So I'm not fumbling through exhibit binders. It's right in my notes, and it makes it a lot more organized, snappier, and professional. I also believe that it's important to have in the notes how you're going to get in any exhibits you want introduced, what rule you're relying on, how you're going to get it in, and anticipating objections. So in a recent trial, I knew that I was going to try to get in test results, which I did get in, and I knew the defense was going to argue Rule 407 on subsequent remedial measure. So I had 3 sentences right in my notes, how I would succinctly answer their objection and succinctly cite to 2 circuit court cases that supported my interpretation as to why it wasn't Rule 407. When you have it right in your notes and you have a quick, pithy answer, your odds of winning the objection go up significantly, and you look professional to the judge and to the jury. The most important thing in preparing and executing cross-examination is, in my judgment, intense preparation. I don't think I've ever spent less than 40 hours preparing for an important witness for cross-examination. And my one rule, which overrules in my judgment and based upon my 30-plus years of experience, Irving Younger's 10 Commandments and other cross-ex gurus, is your judgment and instinct trumps everything. And trust your judgment and instincts, not just the rules of the so-called gurus and experts. But let's take a look at 3 of Irving Younger's 10 commandments of cross-examination. Because I have limited time, I'm just going to focus on a few. One is that he believes that your questions should be brief. And this is what Dr. Younger has to say about his first commandment.
First commandment, be brief. It's a short, succinct. Remember, cross-examination, unless you are Max Square, cross-examination for the rest of us, however, is a commando rate. It's not the invasion of Normandy.
So, let me give some examples from real-world experiences of how brief can be effective. I got super lucky in my very first trial and very first cross-examination. I represented a home builder, and the plaintiff, the homeowner, said the home was negligently built on filled dirt and the home would fall into the ravine. And the plaintiff was a president of a significant corporation in Michigan and was Mr. Slick on direct examination. I'm a kid out of law school, my very first one. So I went up there and I said, "Sir, you have just told the jury that you are unable to fix your property to do the soil movement to prevent your home from falling into a ravine because you could not get a permit from the Department of Natural Resources. Was that your testimony?" "Yes." "Are you certain of that, sir?" "Yes, I am certain." Well, I'd like to show you Exhibit 1, which is in evidence. It's a letter from you to your soil engineer, Mr. Hansen. Doesn't it say at paragraph 3, "Thank you for getting me a permit from the Department of Natural Resources"? He says, "Yes." "So you did get a permit, didn't you, sir?" "Yes." "Let me show you Exhibit 2. Isn't this, in fact, your permit?" "Yes. You got it a year and a half ago, and you've done nothing to try to fix your property, correct?" "Yes, that's true." Now, when you told this jury you could not get a permit, that wasn't the truth, was it? No, it wasn't. And you knew it wasn't the truth. And he says, are you calling me a liar? I said, that's not my job, sir. That's for the jury to decide. I have no more questions. 2-week trial, jury out 20 minutes, they got nothing. It was all downhill after that, because that was my first one. Another example was a case I toiled on as an associate for 4 years. I took or defended more than 100 depositions from coast to coast, representing a home builder suing a manufacturer of defective fire retardant treated plywood used in roof sheathing. It was my job to cross-examine the defense expert in the Middle District of Florida, who had testified for a day and a half about how terrible these homes were constructed, that they were poorly ventilated. That's why the plywood failed. And he had photo after photo and video after video, and they were the ugliest looking attics you've ever seen. A day and a half of him, my cross-examination was maybe 12 minutes. The first thing I did was say, you've been hired by the 5 largest home builders in the United States as their expert in these FRT plywood cases. Is that right, sir? Yes. And I went through how much money he made and how much time he spent with the 5 largest home builders. And I said, my client is number 2. Let's start with number 1. You inspected homes that were built by the number 1 home builder in the United States, right? Yes. Did the product fail in those homes? Yes. And all the homes you inspected? Yes. And you blame the builder, correct? Yes. Wasn't the product's fault according to you, right? Yes. Now, you inspected my client's homes. Product failed in all of them, right? You blame my client. You don't blame the manufacturer, right? 3rd largest manufacturer in the world. Although product failed in all those homes, right? Yes. You blame the builder, not the product, right? Yes. Same with the 4th, same with the 5th. So these home builders annually build approximately 85,000 homes a year. And you're telling this jury that all of these builders got it wrong with this product, right? Yes. And it's the builder's fault, right? Yes. And it's not the product's fault, right? Yes. I have no more questions. That was it. We got a $23 million jury verdict in 1993 on that case. And I think that was one of the reasons why, is the jury could easily see that the expert in their whole ventilation defense had no credibility whatsoever. But sometimes you don't want to be brief. There are exceptions to every rule. Let me give you another example. This was a deposition cross-examination of a plaintiff expert witness who was opining that my client's specialty hospital bed was defective, flipped a patient out of the bed and made him a paraplegic, a very high exposure case. So I start to take his deposition and I ask him about his background, his qualifications, and I can see this guy is an egomaniac. He's talking about how he's well qualified as an engineer to determine products that are defective. So I said, well, give me an example of a product you think is defective. He says, automobiles. I said, which ones? He says, all of them. I said, give me another example. He says, coffee pots. I said, which ones? He said, all of them. What else? Helicopters. Which ones? All of them. I spent 2.5 hours having him identify virtually every common, ordinary use of a product that he believed all of them were defective. His credibility was destroyed before asking even one question about the hospital bed. So go with what the witness gives you. If you have a liar, let him lie. More and more and more, bigger and bigger and bigger. You don't want to be brief in that situation. You want to take advantage of what the witness gives you. And the coup de grace, I couldn't even believe this. I just threw out there, do you have expertise in any other areas? He said, well, veterinary medicine. And I said, veterinary medicine? I don't see anything about that on your CV. And he said, well, I never went to vet school. I said, well, are you licensed in veterinary medicine? No. What is the basis for your expertise? I gave my cat a hysterectomy. So now he's a whack job. And this high exposure case settled for pennies on the dollar. Commandment number 3, use only leading questions. Dr. Younger again.
On cross-examination, you will never ask anything but a leading question. You put words in the witness's mouth. That's the whole idea of cross-examination. That is how you control the witness. That's how you make it go where you want it to go. How long have I been sitting here at home? When a lawyer on cross-examination stands up and says to the witness, what happened next? Oh, no, no!
And so when you do it right and you ask leading questions using their precise words in the contemporaneous documents, using the precise words in their deposition, they're locked in. They know they're locked in. In a recent trial, a very smart witness knew she was stuck, and I got approximately 18 consecutive yes answers. And she was so frustrated, you can see it in her face. She was desperate to get out the defense talking points, but couldn't do it. Because if she said anything other than yes, she was going to be impeached with her own words. The next one is to be prepared. Always have to be extremely well prepared. And the way Irving Younger talks about that is the old don't ask a question you don't know the answer to. That's generally true. But again, and this is one of my main messages, trust your judgment, trust your instincts. I had a trial once where I took the deposition of an installation contractor on a roof. And I could tell that this witness, A, was not very smart, but B, was very honest. And so he gave me all the admissions I needed. You cut a hole in the roof? Yes. You cut it in standing water? Yes. You saw the water flow down the hole into the plant? Yes. You heard a bang? Yes. You saw a fire? Yes. You saw smoke? Yes. The plant shut down? Yes. There's no doubt in your mind that it was you cutting the hole in standing water that blew up the plant's control panel. Correct? Yes. Now, very good defense lawyers on the other side, they had at least 12 that seemingly persuasive theories as to other causations for why the panel blew up. But I think the senior partner may have had heart difficulties when he read that deposition transcript, probably for the first time 2 days before trial. And his side was the nominal plaintiff. We were the counterclaim plaintiff, so he got to go first. So he calls that witness. He tries to take the sting out of it. And his theme was the witness was confused by my questions, that he does not have any idea what caused the panel to blow up. So in cross-examination, what I did is I had a huge blow-up of those questions, which you just heard, and I went through them one by one. You cut the hole. Yes. Anything confusing about that question? No. You did it in standing water, right? Yes. Anything confusing about that question? No. You saw the water go down the hole? Yes. Was that confusing? No. You heard a bang? Yes. Then you smelled smoke and there was a fire? Yes. And you admitted that there was no doubt in your mind that the hole you cut in standing water caused the control panel to blow up. That was your testimony, right? Yes. Nothing confusing about that. Right. Yes. Here's where I took the chance. Did your lawyer tell you to say that you were confused when you weren't? Answer yes. Jurors' jaws drop. We got 100% of what we asked for. But if you apply Dr. Younger, and his ideas are very good, literally you would never have asked that question, and you would not have gotten the full bang out of that testimony. So the last one I want to get to is Dr. Younger's 10th commandment is save it for closing. Use cross-X for your building blocks, but then make the conclusions in closing. I say not necessarily. If you have an opportunity for a kill shot, go for it. So I want to give you a real-world experience that I can talk about because confidentiality was waived. It was an arbitration that I tried for Peter Karmanos against CompuWare. I had the general counsel of CompuWare on the stand, and it went something like this. Sir, Peter hired you? Yes. He made you general counsel? Yes. You became a multimillionaire? Yes. Peter was in charge of your compensation? Yes. Your stock options? Yes. Your perks? Yes. Now Peter leaves CompuWare, Mr. Paul comes in, right? Yes. You knew that Mr. Paul didn't like Peter very much, right? Yes. Mr. Paul instructed you to change the language for the basis for termination to make it easier to fire Peter. Is that true? Yes, it is. And so you changed the language to make it easier to fire him, right? Yes, I did. You presented that to Peter, yes. And by the way, you represented Peter and his wife individually at that time, didn't you, sir? Yes, I did. But now you're representing CompuWare, right? Yes. At the same time, you're representing Peter and his wife. Yes, that's true. Now, when you presented the new language to Peter, isn't it true that he asked you, what does this mean? And you answered in words or in substance, don't worry, Peter. All it means is that you can't be fired unless you commit a major felony. Is that what you told Peter? Yes. Was that true? No. Let me suggest that what you did is you robbed Peter to pay Paul, didn't you? And that was, instead of saving it for closing, just right there, I could see the body language of the arbitrator almost falling off his chair. We got a $16.5 million reward. They had offered us nothing in settlement. We collected every single penny. And it was written about in DB Business. And what was the article? Robbing Peter to pay Paul. Wasn't it a garnishment? So that too. Yeah, we garnished CompuWare's biggest customer, General Motors, which had induced them a little bit to pay us. You know, but Mark's also amazing at collection too. So if you know deadbeats, go to Mark. He is really, really good at that. But the point is, you want to be a tiger. You want to go for the win. You don't want to be mealy-mouthed. You view everything that you do as a trial lawyer, as the trial. No discovery depositions, that's not the way to do it. If you got a chance to kill him, you kill him. So I could go on for hours about cross-examination, but I just wanted to share these insights with you in the limited amount of time that I have. Thank you very much.